The answer is no, it does not. And this is where a lot of problems arise, especially if the person has done their own will or they went to some attorney that didn't take the time to look at the person's entire estate. I mean, all of their assets, all of their bank accounts, you know, their whole situation. And an estate planning attorney, to do a good job, has to be really nosy. We've got to ask a lot of questions. We have to find out, what are your assets and where are they located? You just can't, you know, sign a will and say, oh, well, that covers everything. The reason for that is a will does not cover everything. So just think of it this way. Think of a bank account that you might have. You might have somebody else on the bank account with you. You are joint owners, and you might be joint owners with right of survivorship. So the titling of that bank account, of that asset, says where that account goes when you die. So that account will not pass under your will. That account will go to the joint owner. That's one example. Another example is, think of your life insurance policies or your IRAs or your 401ks. Those should not, do not pass under your will. Remember when you filled it out, there's a beneficiary designation form and it says, on my death, I want this asset to go, you know, you might say to your spouse or to your kids or whatever. But you, by filling out the beneficiary designation, has said where that asset goes. So the will does not capture those assets and funnel them under the will's operation. Those assets go outside of the operation of the will. So it's because of that that people have to have a better understanding of how the will works and how these other assets work, so that we can put them together so it provides the estate plan that the person wants. So let me give you a couple examples of why it's important for the person to understand these issues. And I always take from real world examples. So let's take that single person again, and then they have 3 kids. And in this situation, they want the 3 kids to inherit everything equally. And the will says that. I want everything to go my 3 kids equally, all right? And then somebody thought it was a really good idea, and they told the person, you know what, just make things so much easier. Just put, you know, your one of your kids, let's say it's the kid who is going to be the power of attorney for them, just put them on your bank account. But let's say that this person has a very simple estate. All they have is one bank account. It's worth $300,000, and they put the one child on that bank account with them as a joint owner. You might see what the problem is here. When the parent dies, who's the owner of that one account, that $300,000? Well, just the one child. Now what's going to happen? Well, that one child may say, I know what, you know, mom or dad's wishes are. It's to divide this money up, and they will do that. Or the one child could say, you know what? Mom put me on this bank account because she liked me best, and it's all mine. So that happens. And so what happens after that is the other 2 are going to either live with it, and the whole family is pretty much broken apart, obviously, at that point, or the family is going to go lawyer up the other kids and are going to start litigation, and then it's going to go to court, and a lot of money is going to go out in legal fees. So that's a situation that happens not infrequently. How do you avoid that? You avoid by understanding what it means to put somebody on your account as a joint owner. You avoid that by getting help of an estate planning attorney who helps you walk through your estate plan, so that you would never even think of putting, you know, one kid on your one big asset as a joint owner. One of the reasons that people do an action like that is they say, well, I want to avoid probate. I don't want my will to have to be probated. There are so many ways to avoid an otherwise unnecessary probate. What would have been done in this situation that would have been correct would have been not to make the one kid a joint owner, but to make them perhaps an authorized signer on the account during the parent's lifetime. But on the parent's death, that bank account pays on death, just like a beneficiary designation, pays on death to the 3 children. So they each get 1/3, 1/3, 1/3. There's no room for argument. A correct pay on death direction on that bank account would have solved all of those problems. So a lot of times people want to do their estate planning on their own. And unfortunately, what happens is they just don't know the nuances, the complexities. They take bad advice. Don't ever take legal advice from your neighbor necessarily, unless they are a really good lawyer, or from your friends. Don't ever take it from your bank teller. I mean, financial advisors and accountants, they have understanding, but they can't give legal advice. Only lawyers under the law can give you legal advice. So, be careful where you get your information, because it might mislead you in the wrong direction. I want to give you one more example that is about retirement assets. So I have seen more than one case where the will says, oh, all my retirement assets go here or there. That doesn't work. Your will can't say that. So here is a case that happened in Washington. So husband and wife, they're married. I can't remember which one, but let's say the husband has a big 401k retirement account and they get divorced, and of course it gets divvied up. And so the husband thinks, okay, this is all taken care of. My ex-wife's been taken care of. She no longer has any rights to my 401k. But what the husband didn't realize, and nobody brought it to his attention, he simply didn't know, is that he had to make a change on his beneficiary designation on his 401k. But he didn't do that. So his 401k still said it pays to this person who is his ex-wife. He didn't want that. So you can envision the next step. The next thing that happened is he dies. And then the question comes up, well, who gets the 401k account? Well, the beneficiary designation on it says it goes to the ex-wife. The rest of his family says, no, it doesn't. She is his ex-wife. She doesn't get any of it. Well, this is called the Egelhoff case, and it went up to the U.S. Supreme Court. And the U.S. Supreme Court said 401ks are governed by federal law called ERISA. And under those laws, the Washington law, we had a very favorable Washington law that says, you know what, if you get divorced, we know you don't want your ex to get anything. But the U.S. Supreme Court says Washington law doesn't apply. So under the ERISA law, who got that retirement account was the ex-wife. So really, really not the result that he probably wanted, but that is the result. That is what can happen when people don't understand their assets, don't understand what laws apply. So that's one of the reasons that it really is important to get some good legal counsel to help with your estate planning. Because there's just lots of curveballs. There's just lots of things that can go wrong.